Fetal rights in Canada. Where are we now? Imagine a typical family, a biological father and a biological mother expecting a child. Who has the rights in the situation? You might expect that all three parties would have rights, but in reality, the biological father has 0 rights, the fetus has 0 rights, and the mother has 100% of the rights until the baby is born alive and viable. Then the father and the baby acquire rights. So how did we get here? Let's look at the history of rights through legislation. The Constitution Act of 1867 defined a person as only a man, giving women no rights. Health-related issues were not clearly assigned to levels of government in this act. Federal jurisdiction, as discussed in Section 91, gives the federal government power over criminal matters related to health, such as drugs or food. Provincial jurisdiction, as outlined in Section 92 of the Act, gives provincial governments the power over the creation and regulation of hospitals, abortion procedures, and healthcare profession regulation. In 1960, the Bill of Rights was introduced by Parliament to declare rights and freedoms for all Canadians. However, this bill was not entrenched and easily changeable by Parliament. In 1969, there was an alteration in the Criminal Code to make it legal for doctors to perform an abortion if a committee agreed the pregnancy would endanger the health of the mother. In 1982, the Charter of Rights and Freedoms was introduced in the Constitution Act as a guarantee of equality and individual rights. The Charter was entrenched, making it difficult to amend. Although the Charter has many weaknesses, it has made significant gain in reproductive rights for women, often being applied to define these rights and the role of potential rights for the fetus. The 3 key sections for fetal rights are Section 7, the right to life, liberty, and security of the persons, Section 15, equality rights, and Section 28, the guarantee that men and women will be treated equally. Next is the Morgentaler case. In 1988, that made it legal to get an abortion without any restrictions. It struck down the current abortion law, but no law was introduced afterwards. Morgentaler was a doctor who performed illegal abortions in his clinic. Provincial government tried to limit funding to get an abortion, but ultimately this wasn't successful. Despite the legislation that was previously discussed, there is no formal legislation that discusses or defines fetal rights. Now we look at 2 influential cases that have impacted fetal rights in Canada in some essential way.
The first case, R versus Drummond, was about a 7.5-month pregnant woman named Brenda who carried out an interesting act. She took a pellet gun and fired a pellet into her vagina, which was lodged into the fetus's brain. She claimed she didn't know she was pregnant. The baby was then born 2 days later and suffered an infection in his brain because of the pellet. After the baby was born, she did not mention the incident of the pellet gun, further endangering her newborn. She was originally charged with attempted murder, but the charges were later dismissed. You might be wondering why. This is because the judge agreed with Drummond's defense lawyer, who argued that the Canadian law provides only a remedy for the murder of a person, and a fetus is not defined as a person. Thus, no one can be charged with attempting to murder a fetus. Although Canada does not have any current laws giving the fetus rights over the mother, there have been interesting cases where judges have ruled in favor of the unborn child. One of the fundamental cases where the judge ruled in favor was the Winnipeg Child and Family Services versus DFG. The mother in the case was pregnant with her 4th child. This was brought forward because 2 of her previous children had permanent impairments due to her addiction to stiffing glue. In this case, the courts considered whether the mother's rights outweighed the fetus's rights. Originally, the Manitoba court ruled in favor of the fetus and ordered the mother to be the custody of the director of Winnipeg Child and Family Services and to be put in mandatory treatment. The Manitoba courts came to this decision based on parentis patriae, which is the authorities are given the power to make decisions and protect individuals who are unable to protect themselves. In this case, the fetus. This ruling was only in place for 2 days before it was placed on appeal. The Supreme Court then ruled against the right of the fetus in favor of the mother's rights. They concluded that women cannot be forced to remain in treatment against her will because the fetus was not considered a person with rights. This case demonstrates that a pregnant woman's control over her body and decision are not unchallengeable, even if the decision was only in place for 2 days. The cases mentioned previously created much controversy and debate amongst the Canadian people, court system, and the Canadian government in general. It should be mentioned that the Supreme Court does not state that the legal status of the unborn child could or should not be changed or extended. However, the court has asserted that it is not the role of Canadian judges to make this change, nor given the magnitude of the change and their potential ramifications, would it be appropriate for the court to extend their power to make such an order. The changes to the law sought on this appeal are best left to the wisdom of the elected legislature. So where do we go next?